Fast forward, any come our channel so AG Politics Avenue. Podcast for the training because make headlines. Jembre na EDB Akroma oha. Any me home practice mu say ene EDD kanya. The share which must subscribe to the channel. Hit notification bell so share. Na afia for front so ense into me. Any dey ma onia yenwura aye political highways. Ija dem enya asem koto. Na me no ka say eye Edward Epioko ono ene ye managing director. Ema eye Wontumi mane. Na odi nsem bi akodan eye attorney general onia case no ehu pa anya asem koto. Na mpenia power kira attorney general say prosecution witness no would you to so by and penny and power with my yam or the pedu be a botcher man won't to me any quay of fast or my or forest reserve man no money to me crack quay of fast money china for a shibia impo now omode a year infidia a diagram see a debut any in crata a dear dance and penny and power would to me was operating illegally. Ni nyina no watimi e de asem no ato e attorney general ni ma oni case no ehu na me no ka say Wontumi ene lawyers o ma hwe na o ma anya won to pie dia ene kia na ke 15 years na so for be a professor say no one hwe obako because case no ehu pa with due respect Mr. say you mo ransem ni ye hwe ne yako ene de ba AJ politics
pointers of what we do know. And it's going to be on your screen right now. This is the general manager of Akonta Mining, who is now a prosecution witness. He says Chairman Wontumi promised him 20,000 cedis monthly and a Toyota Land Cruiser V8 as the general manager, but he only received 4,000 cedis monthly for fuel. That's it. That's the former Akonta Mining general manager testifying. Quite a number of things that he said in there. And if you do recall, and let's bring in private legal practitioner Justice Abdullahi joining us right now. And Justice Abdullahi, you do recall that the Chairman Wontumi's lawyers have already raised questions of ethics about the Attorney General having this fourth accused now serve as prosecution witness, the general manager of Akonta Mining. I mean, has the Attorney General done anything ethically wrong in the ensuing matter?
Well, indeed, I mean, to answer a straight question, the answer is absolutely no in this circumstance. But naturally, if I was in the shoes of the accused persons, I'll feel the same level of jittery, considering that the managing director, who has now turned a prosecution witness, is an integral part of this whole prosecution. Indeed, he's in charge of the company. And so he knows the ins and outs of every single thing. And so if such a person turns a prosecution witness, chances are that conviction is almost guaranteed. And so it is normal for me to feel jittery if I was in the shoes of the defense team and all of that. Second, the practice of turning suspects or accused persons into prosecution witnesses is part of criminal jurisprudence of the Commonwealth system. And so every country that practices the Commonwealth system of adjudication what's it called, legal system, has this as part of their criminal judicial processes. And so it is very easy to turn at any stage of the case a witness, an accused person into a prosecution witness. And usually we do that when you know that you have a bigger fish to fry, and so you focus on the bigger fishes. And then the small ones, the fingerlings, you use them as witnesses against the bigger fishes. That is how crime is fought in every part of the world. If you focus so much on the fingerlings, you are likely to be distracted and not nip crime to the bud, because really your focus is not this managing director. He's purely an agent of the company. That's not your focus. In this particular instance, your focus is on the big boys behind the company, those who call the shots, those who make things happen. Those are your focus. And in this particular case, Wontumi is the focus of the state. And so anyone at all that you can turn, you are allowed under criminal jurisprudence to turn the person against those bigger fishes. And so it is part of our legal practice, whether in Ghana, in the US, UK, Canada, and every other Commonwealth country, that when you are prosecuting any person or when you are engaged in criminal prosecution and there are multiple suspects, that you find one more convenient, and if the person, of course, is always about transparency and consent, informed consent. Transparency and informed consent is a watchword here. And so long as the person you are turning agrees, knowing full well of the entire circumstances, the risk involved, and the blessings that it comes along with, and you did not hide anything, and you made it transparent. Transparent here meaning that the court becomes aware of it, the accused persons become aware of it in this instance. You're good to go. The danger is where these things are done under the cover of darkness. I think if you would remember, somewhere last year, we had the Jacquard's case was almost close to that level of turning Jacquard into a prosecution witness, but the way it was handled was the basis for questioning the whole prosecution, and which led to where we are today. But if you really want to do this, you do it such that transparency and openness, as well as informed consent, is the target of the whole thing. Sometimes it could even come along with a witness protection. If you know that the person's life will be in danger, you'd have to afford him some level of protection. And in this particular case, considering the anxiety in the system and how the managing director is reacting based on this decision and the calls that he claims are coming, I would recommend strongly that the Attorney General be looking at some level of witness protections for him, because we can never tell. Right? You do not need to wait until things go south before you say Jack. I would strongly recommend that we look at some level of protection for him to avoid
with this issue. Alfred, isn't there something else you want us to talk about?
But then again, are you saying? Well, are you saying? Well, yes. I summarize his point quite clearly, but you were listening when he was on the point that if indeed these were the challenges that the OSP faced or was facing in preventing Kenneth Ofori-Atta from leaving the jurisdiction, in his view, let the people know, because sovereignty lies in us, the people of the Republic of Ghana.
I'm asking you, what are you expecting the people to have done? When you are going to deploy a strategy, you need to be clear in your mind what the people are going to do. I know he's referring to Article 1.1, Article 35.1. It still would not have produced the result Martin seems to be suggesting. So I don't see that I see it as a non-starter in the first place. What specific action is he talking about? So, and I'm saying, Alfred,
he argues on the path of transparency and some level of trust that, if this is the challenge you're facing, especially with a very topical issue that is of public interest that everybody is talking about, and we've all been asking questions as to why Kenneth Ofori-Atta, that cannot be tried in absentia or be brought back.
Questions. Stop. Get the chronology right. In January, were we asking questions? We're not asking questions in January. It wasn't until after they triggered this thing in February, and then Mr. Ofori-Atta's people responded by March that they will not be available, there was surgery. So let's get the chronology right. What you're saying could not have happened.
But this particular story was in December 2023. A number of these events for which he's been brought, in fact, the questions that he's been asked to answer by the special prosecutor. It's not just one. The SML these issues of the National Cathedral, there were issues that were happening, trending, and we were asking questions.
I'm not getting what you are saying. Listen,
so what do you mean by the chronology of events?
The chronology of events is still the same. Listen, if you have raised issues against somebody, the person is in the jurisdiction, you are anticipating, expecting that you write to the person will respond and be available. You write, I think they wrote, was it in January or was it February? That's still, the process was ongoing. So I'm saying that this issue of all of a sudden, Ken is not available, Ken is not coming, and we are all talking. She's nowhere in January or February of 2025 or whatever. So I don't know what you're talking about.
No, as you talk about the specific chronology of events, reason why you disagree with Martin Kpebu's verdict. And that's why I asked you what exactly you meant by the specific chronology of events, because the reference he makes is to the OSP's own words that, you know what, I'm being blamed for allowing Ken Ofori-Atta to leave the jurisdiction after the elections. And these were the challenges I faced, that his cousin was president. Other institutions that were supposed to help me were not helping. I was asking for help, I wasn't getting. And that's how he got out of the jurisdiction. And Martin Kpebu's point is, to the extent that these were happening and you kept it 10 months on and you're now telling us, what's the effect of this information now?
Listen, I don't understand the logic of your question. Listen,
you don't get the logic.
OSP,
what are we supposed to do with the information now? What he's telling us?
Well, it doesn't matter that he's saying this now. I mean, an unexamined life or any institution that does not review itself over time is one that does not learn from situations. And it doesn't matter that this stage, I think it's a useful thing to say that, listen, at certain points you expect other institutions to act. When they fail to act, then all of us suffer. I think it's a good point to make. It doesn't matter that it's coming at this stage. So I'm not quite sure what you are driving at. I'm saying that between December and January, if the assumption is that telling the people that, look, there are these issues and the man says he's leaving. When the man said that he was leaving for health grounds, you remember?
No. Unfortunately, Adam Senano's connection is a bit cranky. We'll try to get some of it rectified. He's going to be joining us again. Senano, I lost you briefly, but then again, that break leads us to the next issue that we're going to talk about, because today we got to know that CHRAJ has dropped what will be described as a bombshell. The ex-GRA boss is having his problems increasing by the day. There are 3 other firms that are facing possible prosecution. That's coming up next. We've got the details for you. And Reverend Amit Shaddai is having some questions to answer from the Commission for Human Rights and Administrative Justice, CHRAJ. They are the ones who are asking questions right now. They are the key issues. They found that the GRA used single source mode of procurement. Also, we'll give you details of these and more. Stay with us here on Ghana Tonight. Dennis Babari-Wadam is going to be joining me right now to have a conversation on this particular development. And there's been some recommendations that the former commissioner that's a Commissioner General for the Ghana Revenue Authority, Reverend Amit Shaddai Owusu-Amoah, be banned from holding public office for the next 5 years. Now, the findings referred the former GRA boss to the Attorney General for possible prosecution. Now, we've got full details of what CHRAJ found and what they are recommending. Dennis Babari-Wadam Esquire is joining me. Dennis, it's always good to have you join me here. But what more do we know about this latest from CHRAJ?
Well, so Alfred, this complaint before CHRAJ had to do with some observations that a civil society group had made in respect of some procurement processes that GRA had done in respect of some vehicles. GRA had contracted 3 companies to procure some vehicles for them. It was the observation of this civil society group that these 3 companies that were contracted, they could not find the registered addresses of some of those companies. That is to say, if an address was provided in the correspondence between GRA and that company as being the registered office address of that company, if you trace that address, it will lead you to a place where you will not find that office.
Right.
So, for instance, if you provided an office address like TV3 here at Disawe Kanda, then you come here, you don't find this office space.
Yeah.
That's a typical example. So that was one of the issues for which they were suspicious that there could be something more to it than just the contract. They also made the observation that, I mean, looking at the amount of money involved in the purchase of the vehicles, they were of the view that the prices may have been inflated. So that was another concern they had. Also, even with the capacity of the companies to deliver on the contract, there were also issues in question, because they also found out that the companies indeed could not deliver as was agreed, because within the time frame that they were given to deliver the vehicles, they couldn't do so. There was an extension. They still could not deliver within that extension. So that in itself raised some questions. There was also issues of tax evasion and all that. So they put the matters before CHRAJ, asking CHRAJ to look at it. It's also instructive for us to put on record that CHRAJ itself had indicated that along the line when they took assumed jurisdiction over the matter, they got into the process of investigating. Then the lead convener for this particular civil society group organization served them a notice of withdrawal. That is to say, they wanted to withdraw the complaints. Now, per the rules of law, as applies to the office of CHRAJ, they cannot on their own investigate a matter unless somebody petitions or complaints. That could either be orally or written. Now, it raises the question as to whether the withdrawal of that complaint brings the matter to an end. So CHRAJ had to take a decision as to whether to proceed or not. In the view of CHRAJ, they had already gone to an advanced stage in dealing with the matter. And then again, it was their view that this was not just a matter that the complainants alone had an interest. It was a matter of public interest, for which they took the view that they needed to proceed with it. So they did all the necessary interviews with all those who matter, and they got all the necessary documents in aiding that investigation. Now they had to answer questions as to the other issue, which I didn't mention, is the fact that they also raised issues as to the kind of procurement that was used. Because the complainant said it was a restrictive tendering process. But as CHRAJ would find out, it was actually a single source, or what we commonly call the sole sourcing, which CHRAJ had identified. That's what you see as one of the key findings that CHRAJ made, in that the commission found the GRA used a single source mode for the procurement. Now, the question of whether the companies indeed had capacity or not, CHRAJ made the findings that, yes, the companies did not possess the requisite competence to carry out a contract of such magnitude, and that the companies were unqualified to be engaged for public procurement because they had no evidence to show fulfillment of tax and social security obligations. As this also shows, the companies indeed could not deliver as was expected under the contract, because even with the extensions, they could not still deliver the required number of vehicles. Per CHRAJ's estimation, that the vehicles that were procured from one of the companies named Renault Motors were actually inflated, as was the observation by these complainants or the civil society group. And that resulted in the financial loss to the state in the sum of $826,551 United States dollars. Now, there were also the issues that have to do with allegations of fraud. CHRAJ, in its findings, says that yes, there was a blatant disregard for procurement rules, fraudulent misrepresentations, and lack of due diligence, which led the commission to conclude that the respondent in this matter is the former GRA Commissioner General that engaged in fraud and corruption. Now, the issues that had to do with the tax component, that the 3 companies had not paid tax in full in full as required by the tax, and this was as of the date of the complaint. There were other findings, which now had to do with the locations of the company, and that's where it gets very interesting. That, for instance, failed investigations to verify allegations that neither Telino Ghana Limited or Rajel Motor and Trading Company Limited had business offices. Now, this is it. Telino was supposed to be operating as was provided in their address.
We ain't some who do course watching on the so I'm not so Jim or say Obadi India don't be Edomania. Besamba room, not just some politics.